Hello, I'm Ken Harrell, and I'm the managing partner of the Joy Law Firm in South Carolina. I'd like to speak with you a few minutes about the importance of having an experienced workers' compensation attorney assist you with settling your workers' compensation claim if you sustain a disabling injury to ensure that you protect your future Social Security disability benefits. I've often been asked by injured workers whether they should hire a lawyer to assist them with their workers' compensation claim. Obviously, the answer to that question will vary from case to case, depending on the specific facts involved in the case. If someone has sustained a relatively minor injury and they've been able to return to work after missing little or no time, they often are not going to need an attorney to help them unless they're going to have some significant future medical needs. However, there's one situation where I would tell any injured worker that they absolutely have to hire an experienced attorney, and that's when the injured worker believes that he or she may end up being totally disabled as a result of the injuries they've sustained on the job. There are a couple of reasons why I would tell you that you should definitely hire a lawyer in that situation. First, no insurance company is going to voluntarily pay you disability benefits. All insurance companies have one thing in common. They love receiving premiums, but they hate paying benefits. Another reason why it is important that you have an attorney assist you with your settlement in a disability situation is to make sure that appropriate proration language is put into your settlement agreement to protect your future Social Security disability benefits to the greatest extent possible. There's nothing which prohibits someone from receiving workers' compensation and Social Security disability benefits at the same time, although there may be instances where your lawyer would advise you to hold off on applying for your Social Security disability benefits while your workers' compensation case is pending for settlement purposes. However, if you do end up receiving Social Security disability benefits while you're receiving workers' compensation benefits, the Social Security Administration will generally receive a credit based on the workers' compensation benefits you are receiving. One way to significantly reduce, and in some cases to extinguish this credit once your workers' compensation case is settled, is by ensuring that appropriate proration language is put into the settlement agreement, prorating the net amount you receive from the settlement over your life expectancy under South Carolina law. Now, this is a very complicated topic, but I can assure you that the failure to include this language in the settlement agreement can end up costing your family and you tens of thousands of dollars in Social Security disability benefits. Frankly, if an injured worker's attorney fails to have this language placed into a settlement agreement when the injured worker has been disabled due to their injuries, this may very well constitute legal malpractice. I've had some injured workers ask me whether they can rely on the workers' compensation insurance company or the insurance company's lawyer to place this language into the settlement agreement. The answer is absolutely not. The insurance company and its lawyer are not going to put themselves in a position where they can be held responsible for giving you faulty legal advice. The insurance company's lawyer's obligation is to represent the insurance company, and it would be a conflict of interest for this lawyer to also give you advice. Again, if you've been disabled or if you feel you've been disabled as a result of a serious work injury, I strongly urge you to hire an experienced workers' compensation attorney, whether you hire our law firm or someone else. If you would like to receive more information about our law firm, I'd recommend that you visit our website at www.joylawfirm.com. If you would like to speak with one of our workers' compensation attorneys, please call us at 888-324-3100 or feel free to email me directly at kharrell@joylawfirm.com. Please understand that there is never any charge to speak with us about your claim. For all claims which we handle on behalf of injured workers, we do the same on what is called a contingent fee basis, which means that we're only paid if we're able to obtain a recovery for you. I hope the information in this video has been helpful to you, and I appreciate you watching the same. Thank you.